Real estate agent license practice test. Question 1. Personal property that, by its attachment to real property, is regarded as real estate is called underscore 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 underscore. An emblement, personality, a fixture, an appliance. When personal property is attached to real property to such an extent that a person cannot extract the item from the real property without damaging the real property, the item is a fixture. Another test to determine whether an item is a fixture is whether the item is so adapted to the real property that to remove the item will diminish the value or utility of the real property. Of course, if the purchase contract specifically includes a certain item with the sale of the property, that item must be regarded as a fixture, whether it meets the legal definition of fixture or not. Likewise, if the purchase contract specifically excludes an item from the sale, it must be regarded as personal property and should be removed. Question 2. Which of the following lists correctly describes the physical and economic characteristics of real estate? Immovable, indestructible, unique, scarce. Depreciable, indestructible, scarce, unique. Unique, immovable, abundant, indestructible. Movable, indestructible, scarce, unique. Land is characterized as immovable because an entire parcel of real estate cannot be moved to another site. Land is considered indestructible because, in contrast to buildings, an entire parcel of real estate theoretically cannot be destroyed and or need to be replaced. Land is considered unique because, at the very least, each parcel of real estate has its own different and distinct place on the planet. Finally, land is considered scarce because entire new parcels of real estate cannot be manufactured. Test-taking tip: because the words unique and indestructible are in each answer choice, you do not need to spend valuable exam time considering them. B is incorrect. Land does not depreciate. Why not? Because, in contrast to a house or a building, an entire parcel of land does not wear out and need to be replaced. Test-taking tip: make sure you remember this rule for your exam. Land does not depreciate. C is incorrect. Despite there being a lot of land, land is considered scarce as brand new parcels of land cannot be created through human labor. D is incorrect. Land is not considered movable. While topsoil or even a building can be moved, an entire parcel of real estate cannot be moved to a new location. Question 3. If a person has complete control over their property, and the ownership in the property is not defeasible, what interest does the person have in the property? Fee conditional estate, fee simple estate, life estate, defeasible fee estate. A fee simple estate is ownership that gives a person or entity complete control, subject to standard governmental restrictions. A life estate gives a person ownership or control of a property only for the duration of his/her natural life. Defeasible estates, estates which can be defeated, give a person or entity control over a property only so long as certain conditions are met or avoided. Question 4. Juliana and Daniel own two contiguous properties situated on the shores of a fast-moving river. Juliana's parcel is situated upstream from Daniel's parcel. Over time, the action of the river's water has moved some silt and dirt from the shores of Juliana's property and deposited it downstream on the shores of Daniel's property. Based upon this fact pattern, which of the following lists best describes what has occurred on Daniel's property? Alienation, attachment, alluvium. Accession, literal, standing water. Assemblage, plottage, increased value. Accession, accretion, alluvium. This series of words best describes what has happened on Daniel's property. As it pertains to real estate, accession means to acquire more land, even a small amount of land. Accretion is accession that occurs through natural causes. Here, what happened on Daniel's land is accession by accretion because the natural action of the river's water deposited silt on the shores of Daniel's property. Finally, alluvium is a technical term for the silt/dirt moved by the river from Juliana's shores and deposited on Daniel's shores. A is incorrect. Alienation means to separate real estate from its owner. Alienation can occur either through voluntary means, example sale, gift, dedication, etc., or involuntary means, example foreclosure, tax sale, adverse possession, etc. Here, Daniel is acquiring property, not losing it. Answer choice A is also incorrect because of the word attachment. While attachment is property gained through accession, attachment is created through human intervention. For example, if a tenant had rented Daniel's property, constructed a shed on it, and then left the shed after the lease was over, that would have been an example of accession by attachment. Here, Daniel is gaining additional property through the natural action of the river's water, i.e., accretion. B is incorrect. Literal has to do with rights of owners who live by standing water, like a lake, a pond, or the ocean. There is nothing in the fact pattern to suggest either parcel of property is near a body of standing water. C is incorrect. These terms are used by appraisers to describe the increase in value when an owner combines several contiguous or touching parcels into one large parcel. The act of combining several parcels into one parcel is called assemblage. The increase in value that should result from the consolidation is called plottage. Example: 5 separate parcels each have a value of $100,000 totaling $500,000. After assembling them together into one large parcel, the value of the one large parcel is $525,000. The additional $25,000 is plottage. Question 5. A woman who owns a parcel of real estate in Sévérité wants her son to have the property, but only after she dies. Which of the following choices is correct and will accomplish her wishes? A devise in a properly executed will. A life estate in which the son is the life tenant and measuring life, and the woman is the remainderman. Alienation via a delivered and accepted quitclaim deed. Since the property is owned in Sévérité, the other owners will need to be consulted. After the woman dies, her debts will be paid and assets distributed through the probate court. When a parcel of real estate is transferred through the probate court as per the terms of a valid will, it is called a devise. Test-taking tip and inheritance of personal property, by contrast, is called a bequest or a legacy. B is incorrect. This answer choice reverses the woman's wishes. In order to comply with the woman's desires with a life estate, the woman should be the life tenant and measuring life, and the son should be the remainderman. C is incorrect. To alienate means to convey. A deed that has been delivered and accepted would result in an immediate transfer of the real estate from the woman to her son. D is incorrect. An estate in Sévérité, aka a tenancy in Sévérité, is ownership by one person. When a parcel of real estate is owned in Sévérité, there are no other owners to consult. Test-taking tip: one person, one corporation, one governmental entity, one trust, one partnership can all own real estate in Sévérité. As long as there is only one owner, that is an estate in Sévérité. Examiners like to test this because of the word several in Sévérité. Question 6. For a deed to be valid, it must be signed by the grantor, signed by the grantee, recorded at the state level, all of the above. A deed must be signed by the grantor, i.e., the owner conveying an interest in real estate to someone else. B is incorrect. The grantee does not have to sign the deed. The grantee must accept delivery of the deed, but that can be achieved through possession of the deed, taking possession of the property, taking out a loan on the property, etc. C is incorrect. For most states, official records are recorded at the county level. Question 7. Of the many expenses involved with owning a house, which of the following are tax-deductible? Property taxes, insurance, interest, both A and C. Capped at $10,000, property taxes are deductible. With some restrictions, interest on a mortgage loan is also a tax-deductible expense for homeowners. In fact, this is considered one of the major tax advantages of homeownership. Note: discount points, i.e., prepaid interest, is also tax-deductible. B is incorrect. Insurance, example fire, comprehensive, title, etc., is not a tax-deductible expense. Note: homeowners association dues and home repairs are not deductible. Question 8. Which of the following is the difference between the value of a property and the total amount of liens against the property? Investment, basis, down payment, equity. Equity is not directly affected by the purchase price for the property, nor is it directly affected by the amount of down payment put forth at the time of the purchase. Many owners are under the misguided belief that a high down payment will always result in high equity. This is only true if the market value of the property remains the same as it is when the down payment is given, or increases after the down payment is given. If the market value of the property decreases, the equity in the property will decrease also, regardless of the purchase price and down payment amount. Question 9. A parcel of residential real estate is held in a life estate. The life tenancy is held by a woman, and she is the measuring life. Her nephew is the remainderman. The life tenant wants to take out a loan using the property as collateral. Which of the following statements is correct? No lender will lend money when the collateral is real estate held in a life estate. The remainderman's signature on the loan documents is irrelevant to the lender's security interest in the realty. Because she is merely a life tenant, the woman holds a non-freehold estate. Both the life tenant and the remainderman will need to sign the loan documents to protect the lender's security interest in the property. The life tenant, i.e., the aunt, can take out a loan on the property without the remainderman's signature. However, if only the life tenant signs the loan documents, then the debt will die with her. In order to protect the lender's security interest in the event of the aunt's death, both the life tenant and the remainderman will need to sign the loan documents. The same would be true if the property were being sold. Both the life tenant and the remainderman would need to sign the deed in order to ensure that the buyer's ownership interest in the property would continue after the life tenant dies. Test-taking tip: remember, a life estate is an estate of ownership, aka a freehold estate. With a life estate, there is a present interest and a future interest. A simple way to figure out who owns each interest is to ask yourself the following two questions: who has the right to possess the property in the present? Here, the aunt does. She holds a present interest in the property, and, because she is the measuring life, she will hold that interest until she dies. Who will have the right to possess the property in the future? Here, the nephew does. He holds a future interest in the property. A is incorrect. Provided that both the life tenant and the remainderman sign the loan documents, the lender's security interest in the real estate will be protected if the life tenant dies during the term of the loan. B is incorrect. If the remainderman does not sign the loan documents, the lender's security interest in the real estate will terminate upon the death of the life tenant. C is incorrect. A non-freehold estate is a leasehold estate. A life estate, by contrast, is a freehold estate, i.e., an estate of ownership. Question 10. There are 4 separate, recently sold parcels of real estate on Main Street. Parcel 1 was owned by a real estate investment trust and was voluntarily conveyed to the city where the property is situated. Parcel 2 was owned by 4 unmarried brothers and was voluntarily conveyed to their father. Parcel 3 was owned by 2 corporations, until one corporation recently sold its ownership interest in the property to the other corporation. Parcel 4 was owned by Mr. and Mrs. Kim, but was recently sold to Amanda Lee, trustee of the Lee Family Revocable Trust. What do all of these buyers have in common? Concurrent ownership, ownership in severalty, fractional but undivided ownership, right of survivorship. Ownership in severalty occurs when there is only one owner of a parcel of real estate. The owner can be, for example, an individual, a corporation, a governmental entity, a trust, or a partnership. As long as it is sole ownership, it is an ownership in severalty, aka an estate in severalty. Test-taking tip: this is frequently tested because of the word several in severalty. A is incorrect. Concurrent ownership occurs when there are multiple owners of the same parcel of real estate holding title together at the same time. C is incorrect. If there are multiple owners, example, one owner owns 90%, a second owner owns 9%, and the third owner owns 1%, ownership is described as fractional, but undivided. This means that no matter how small their ownership interest is, each owner has an equal right of possession as to the entire parcel of land. D is incorrect. If 2 owners hold title with a right of survivorship, and one owner dies, then the survivor acquires the decedent's interest in the property automatically, through operation of law. Depending on the state, common ways to hold title with a right of survivorship include tenancy by the entirety, joint tenancy, and / or community property with right of survivorship. Question 11. A meets and bounds legal description ______________ can be created only for areas excluded from the rectangular survey system. Is not acceptable in a court in most jurisdictions. must commence and finish at the same identifiable point, is used only in extreme cases where there is no recorded subdivision plats. A metes and bounds legal description begins at a well-defined point of beginning or POB, and follows the boundaries of a parcel of land, using directions and distances around the tract, and ends at the point of beginning. When properly written, it is acceptable and enforceable in all court jurisdictions, and can be created for any parcel of property. Oftentimes, a deed will contain two types of land description. Generally, a metes and bounds description is accompanied by a rectangular survey, or government survey, description or lot, block and tract description. Question 12. Your neighbors use a portion of your property to reach their guest apartment, which is on their property. As far as you can recall, you never gave them permission to use your property, and you discuss with your attorney the possibility of preventing the neighbors from using your property. Your attorney explains that the ownership of the neighbor's real estate includes an easement appurtenant giving them the right to use that portion of your property. Your property is the leasehold interest, dominant tenement, servient tenement, license property. An easement appurtenant allows the holder of one property to benefit from another's. In this case, your property is servient because it is the one burdened by the easement, while your neighbor's is dominant since it is the one that benefits. If you would have given permission to the neighbors to use your driveway, you would have effectively licensed the neighbors, not the property. The word license is not typically used as an adjective for the word property. Question 13. The owner of a large parcel of real estate legally divided it into two smaller parcels. Parcel north was directly to the north of parcel south. The only road in the area bordered parcel south. The owner intended to keep parcel north, and wanted to prevent it from becoming landlocked. In the deed to the buyer of parcel south, the owner reserved a non-exclusive easement for ingress and egress purposes over the westerly 8 feet of parcel south. After both parcels were sold to two new owners, the new owner of parcel south fenced in the entire parcel, making ingress and egress over the westerly 8 feet impossible for the new owner of parcel north. In a lawsuit between the new owner of parcel north and the new owner of parcel south, who will most likely win? The owner of parcel north. An easement appurtenant cannot unilaterally be terminated by the servient tenement. The owner of parcel north. An easement in gross cannot unilaterally be terminated by the servient tenement. The owner of parcel north. Because there is no other access to a road, this is an easement by necessity. The owner of parcel south. The right to exclude non-owners is a fundamental right of property ownership. The easement described in the test question is an easement appurtenant. The old owner, who split his large parcel in two, created the easement by reserving it in the deed to the individual who first purchased parcel south. In an easement appurtenant, there is a dominant tenement, i.e., the parcel that benefits from the easement, and a servient tenement, i.e., the parcel that is burdened by the easement. Here, the parcel that benefits from the easement is parcel north because the easement allows the owner to cross over the westerly 8 feet of parcel south to get access to the road. Parcel south is burdened with the easement because people who don't even own the land are allowed to use the westerly 8 feet of parcel south for ingress and egress purposes. The owner of a parcel of real estate burdened with a servient tenement cannot unilaterally terminate an easement appurtenant. An easement appurtenant runs with the land and transfers with the deed. Therefore, by fencing in parcel south, the new owner of parcel south will most likely be found to have violated the easement conditions and will lose the lawsuit. B is incorrect. An easement in gross only has one parcel of land, a servient tenement. The classic example of an easement in gross is a public utilities easement. The public utility does not need to own a contiguous parcel in order to have an easement in gross. This test question states that there are two parcels of land, a dominant and a servient tenement. Therefore, this fact pattern does not describe an easement in gross. C is incorrect. A landlocked property is one without access to a street or road. An easement by necessity is created by the courts when a property is landlocked, provided that the owner of the landlocked parcel did not create the problem. Here, when the old owner split the large parcel into two, the old owner carefully reserved an easement over parcel south, preventing parcel north from becoming landlocked. Because the old owner reserved an easement in the deed, there was no need to go to court and ask for an easement by necessity. D is incorrect. This answer choice states the general rule, but the owner of parcel south purchased the property subject to the easement. Because easements appurtenant run with the land, the easement is binding on the new owner of parcel south. Test taking tip: pay close attention when you see answer choices that are almost identical like A and B. Frequently, when two choices are so close, this is what the examiners are testing. Question 14. Which of the following is protected by the Federal Fair Housing Act? Behavior, age, marital status, minor children. Familial status is a protected classification under the Federal Fair Housing Act, as amended. When first enacted in 1968, the law prohibited discrimination in housing only on the basis of color, race, national origin, and religion. An amendment in 1974 added sex as a protected class. In 1988, the federal law was further amended to add two more protected classes: familial status, to protect families with minor children and pregnant women, and handicap/disability, including those afflicted with HIV/AIDS. Test taking tip: you need to have this federal law including the amendments memorized before taking your state exam. A, B, and C are not protected classes under the Federal Fair Housing Act. Question 15. A major institutional lender discriminates against certain prospective borrowers based solely upon their homes being located in depressed neighborhoods. The lender does this by giving no consideration to either the condition of the specific property or the creditworthiness of the prospective borrower. What is the name of this illegal activity? Redlining, silent second, heir loans, backward applications. Redlining is the illegal denial of a loan application based upon the location of the securing property without any consideration of the employment history or creditworthiness of the loan applicant or of the condition of the property itself. This activity got its name from the maps that lenders used to have up in their offices. Certain geographic areas, usually in economically depressed or crime-filled neighborhoods, were encircled with a red line. If the property was within these red lines, the loan application would be declined. B is incorrect. A silent second is a loan between the buyer and the seller for part or all of the down payment. The name comes from the fact that buyer and seller do not tell the primary lender about the loan, thereby silently increasing the amount of debt the buyer is carrying. Silent seconds are a type of mortgage fraud and are illegal. C is incorrect. An heir loan is another type of mortgage fraud perpetrated upon lenders. This involves getting a mortgage loan on a parcel of real estate that does not exist. D is incorrect. A backward application is another type of mortgage fraud committed on lenders. Here, the buyer finds a desirable property and lies about his or her income in order to qualify for a purchase money mortgage. Question 16. A county government was widening a highway. Prior to construction, the county had to demolish certain dwelling houses and commercial retail properties bordering the old highway. After the legal proceedings were complete, several residential property owners refused to leave their former homes. The sheriff removed several individuals forcibly. In one case, the sheriff was forced to drag an elderly, protesting woman out of a house she had owned for decades. What is the name of the governmental power? Condemnation, police power, eminent domain, escheat. As stated in the Fifth Amendment to the U.S. Constitution, governmental entities have the right to take private property for public purposes. This power is called eminent domain. Taking private property to widen a highway is a classic example of when the government, example city, county, state, or federal, would exercise its power of eminent domain. However, the Fifth Amendment to the U.S. Constitution does state that government entities exercising this power must pay the private property owners just or fair compensation. A is incorrect. Condemnation is the name for the legal proceeding to determine what just or fair compensation is for each parcel of real estate taken by the government. It is not the name of the government power itself. B is incorrect. The government's police power is the right of the government to establish and enact laws to promote public health, public safety, public welfare, and morals. Two classic examples of police power are zoning and building codes. Test-taking tip: when the government exercises its police powers, typically no compensation need be paid to affected property owners. D is incorrect. In our legal system, real estate must be owned by someone. In England, if the owner abandoned a parcel of real estate or died without a will, i.e., intestate, and without heirs, the property reverted back to the original owner, the Crown. In the United States, this parcel of real estate would revert back to the state. This governmental power is called escheat. A test-taking tip: in addition to police power, eminent domain, and escheat, the government also has the power to tax real estate. Your memory aid for these 4 governmental powers over land is PEAT: police power, eminent domain, taxation, and escheat. These are 4 separate powers. Be careful not to let the examiners trick you into lumping several powers into, say, police power. Question 17. The zoning laws in your town require an apartment building to provide 2.5 parking spaces for every 1,000 square feet of inhabited space. A local apartment building has 20,000 square feet of apartments. How many parking spaces should it have? 40, 50, 45, 55. 20, 1,000 square feet, x 2.5 parking spaces, 1,000 square feet, equals 50. Question 18. There are no nationwide or statewide zoning laws. True, false. There are no nationwide or statewide zoning ordinances, but governments may regulate land use through special legislation such as national park regulations, wildlife preserves, coastal management, and environmental laws. Zoning laws, as implemented in cities and counties, identify the permitted use of each parcel of land. Question 19. The illegal and discriminatory practice of underscore 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 occurs when one person induces another to enter into a real estate transaction by insinuating that the real property values in neighborhood will decline as a result of a member of a protected class buying property in that neighborhood. Blockbusting, redlining, boycotting, neighborhood canvassing. Blockbusting, for the most part, is no longer a common practice, although it may happen indirectly through inappropriate conversations and statements by real estate licensees. The purpose of the blockbusting scheme is to get the homeowners to sell out at a deflated price, then sell the vacated homes to minority group members at an inflated price. Involvement in a blockbusting scheme is grounds for criminal charges. Question 20. An agent, broker or lender who is blockbusting is trying to scare owners in a neighborhood into selling their property. True, false. Blockbusting is also called panic peddling. Blockbusting is the illegal attempt by a real estate professional to obtain listings. Real estate licensees engaged in panic peddling by frightening homeowners with the prediction that minority members moving into the neighborhood would result in increased crime and declining property values. This now illegal practice was historically profitable for real estate professionals, and frequently resulted in homeowners selling at a loss. Question 21. What is the main purpose of police power? To protect the health, safety, and welfare of the community. To prevent people from committing crimes. To put out fires. To make sure the property owners and citizens know their place. The U.S. Constitution limits government power and requires that governmental actions and statutory regulations cannot take away property rights without due process, unless there is a compelling government interest to do so. Protecting the health, safety, and welfare of the citizens of the community has long been accepted as such a compelling government interest. Police power is the power of the state to enforce laws and rules that protect the members of the community. Since owners take title to their property subject to zoning laws, enforcement of the zoning laws is constitutional. Question 22. What is the difference between a specific lien and a general lien? A specific lien is secured by a specific piece of property, and a general lien is secured by the collective assets of the person against whom the lien is held. A general lien is secured by a specific piece of property, and a specific lien is secured by the collective assets of the person against whom the lien is held. Specific liens require collateral, and general liens do not. General liens require collateral, and specific liens do not. Specific liens are secured by a specific piece of property. General liens are secured by the collective assets of the debtor. Many borrowers are under the misguided impression that there is no collateral securing a general lien, such as a credit card lien or signature loan. While both types of liens require collateral, General liens are actually secured by more collateral than specific liens. A lien holder of a general lien is within its rights to foreclose on any of the assets of the debtor, whereas a lien holder of a specific lien may only foreclose on the specific collateral named in the lien. Question 23. Emily Young is selling her 2-bedroom, 1-bathroom condominium. She enters into a written exclusive right to sell listing agreement with a local real estate licensee. Which of the following correctly states the agency relationship created by this type of listing agreement? Express agency, general agency, universal agency, implied agency. The test question states that the listing agreement was formalized in writing. An express agency is one that was formalized before the fact either verbally or in writing. The traditional rule, in the Statute of Frauds, states that a listing agreement cannot be enforced in court unless it is in writing and signed by the party to be charged. Test-taking tip: because it is frequently tested, it is worth reviewing the other promises, agreements, and contracts that must be in writing to satisfy the Statute of Frauds. B is incorrect. A general agency usually gives the agent a limited ability to bind the principal. Example: a property manager has the ability to find and sign qualified tenants on behalf of the property owner. This is typically used in an ongoing business, where the agent has multiple duties to perform. In contrast, the special agent acting under the authority of the exclusive right to sell listing agreement typically only has the sole duty of finding a buyer. Special agency is an advisory position, and the agent traditionally lacks the authority to bind the principal. Example: a listing agent can solicit offers, but lacks the power to accept an offer and bind the seller. C is incorrect. A universal agency gives the agent broad powers, including the authority to bind the principal. A power of attorney is an example of a document that might set up a universal agency. Test-taking tip: the agent created by a power of attorney document is called an attorney in fact. This person does not need to be an attorney. D is incorrect. An implied agency is created through the actions of the two parties. Here, the test question states this listing agreement was created before the fact and is in writing, making it an express agency, not an implied agency. Question 24. All of the following are agency relationships except underscore 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 underscore. The attorney-client relationship. The real estate salesperson-buyer relationship. The real estate broker-buyer relationship. The listing broker-seller relationship. Although a salesperson likely refers to himself/herself as an agent, the salesperson is not an agent. The broker is the agent. The salesperson owes all of the fiduciary duties to the client, principal, that an agent owes, but most all of the agent's real estate-related activities must be supervised by a broker. Question 25. Two managing brokers from different brokerage got together to play golf. During their private round of golf, the two brokers quietly decided that the commission rates for the two brokerage firms should match. This is an example of legal behavior permitted in a free market economy, illegal behavior under the Sherman Antitrust Act, illegal discrimination under federal fair housing laws, prohibited by the Statute of Frauds. Quietly fixing brokerage firm commissions is the anti-competitive, collusive behavior that the Federal Sherman Antitrust Act made illegal in 1890. A is incorrect. Since the Federal Sherman Antitrust Act of 1890 was enacted, firms, including real estate brokerage firms, have been legally prohibited from engaging in anti-competitive activity like fixing prices, fees, or commissions. Other prohibited acts include dividing up geographic territories or boycotting brokers offering cut-rate discounts. C is incorrect. There is nothing in the test question to suggest that the two brokers are engaging in housing discrimination. D is incorrect. The Statute of Frauds is not related to price fixing. The Statute of Frauds requires certain contracts and agreements be formalized in writing in order to be enforceable in a court of law. Question 26. As it pertains to a real estate brokerage firm, a company dollar is the income of the brokerage firm after paying licensee commissions, the income of the brokerage firm before paying licensee commissions, office expenses divided by brokerage associates, a Section 1031 tax-deferred exchange. A company dollar is what the brokerage firm has left after licensee commissions have been paid. B is incorrect. A company dollar is what the brokerage firm has left after, not before, paying licensee commissions. C is incorrect. This answer choice describes the term desk fee. D is incorrect. The term company dollar is not associated with the IRS 1031 tax-deferred exchange. Under Section 1031 of the United States Internal Revenue Code, capital gains taxes may be deferred for real estate used for business or investment purposes if the parcel of realty is exchanged for another like-kind parcel. This allows property owners to defer paying federal capital gains taxes until the new parcel of real estate is sold. Note, in a 1031 exchange, like-kind doesn't mean identical. A like-kind parcel of real estate is one that is used for business or investment purposes, meaning an office building could be exchanged for an apartment building. Question 27. A broker collects a non-refundable fee from the seller when the listing is signed to cover the advertising of the property for sale. Such a fee is called an advance fee and is considered trust funds. True. False. An advance fee given by the seller to cover advertising costs is considered trust funds. Most states have very strict rules governing the handling of trust funds. Generally, the funds must be used only for their intended purpose, and an accounting of all expenditures must be provided to the principal. If the money is not used for its intended purpose, it must be returned to the principal. Question 28. As a seller's agent, you sell a house for $135,000. The selling price includes a 6% commission rate that your brokerage charges. The buyer's agent will get half the commission. What is your portion of the commission? $2,025, $4,050, $8,100. None of the above. $135,000 x .06 equals $8,100. $8,100 divided by 2 equals $4,050. Question 29. A seller and a broker enter into a written listing agreement for the seller's 2-unit dwelling. The broker is authorized to advertise, stage, and solicit offers on the property. The broker's duties also include advising the seller as to the advantages and disadvantages of offers received. However, the broker cannot accept an offer and bind the seller. This is an example of what type of agency? Special agency, general agency, implied agency, dual agency. The fact pattern describes a special agency created by the listing agreement. In a listing agreement, the seller is the principal and the listing broker is the agent. When a special agent, the broker typically has one task or duty. That duty is to find a ready, willing, and able buyer for the seller's property. A special agency is an advisory position. Therefore, while the broker can advise the seller as to the merits of each offer, the broker does not have the authority to accept a particular offer and bind the seller to that decision. B is incorrect. In contrast to a special agency, a general agent typically has a number of duties to perform. This type of agency is usually used for ongoing businesses. The general agent does have a limited authority to bind the principal. One frequently tested example of a general agency is a property manager with the authority to, for example, find and sign well-qualified tenants. C is incorrect. An implied agency can be created unintentionally or by accident. It may be created accidentally through the speech or actions of the agent, example, the broker for the seller advising a stranger who drops in at an open house. This answer choice is incorrect because, here, both parties intended to enter into an agency relationship and formalize that intention in a written listing contract. D is incorrect. A dual agency occurs when the agent represents more than one party to the transaction, example, representing both the buyer and the seller in a purchase transaction. There is no dual agency scenario presented in this fact pattern. Note, some states legally prohibit dual agencies. Question 30. You can only legally receive a commission from your employer. True. False. Only a real estate licensee who is authorized by law to work independently can receive a commission directly from a member of the public. If not legally authorized to work independently, a real estate licensee can only receive a commission from the employing broker. This gives the employing broker additional control to ensure that, among other things, the transaction record is complete, fair housing laws are followed, and the appropriate disclosures are made in a timely fashion. Question 31. A seller and a real estate licensee enter into a listing agreement for a valuable property that is located in a desirable neighborhood. The listing agreement is a bilateral contract and includes a specific end date. The licensee agrees that, in the event the seller finds a buyer, the licensee will not receive a commission. What is the name of the listing agreement? Exclusive right to sell, exclusive right to buy, exclusive agency, open. In an exclusive agency listing agreement, if a buyer is found, the licensee will earn a commission, unless the seller finds the buyer. With the exclusive agency listing agreement, there is only one brokerage firm. Also, the licensee has a limited, clearly defined period of time in which to find a buyer. Finally, the exclusive agency listing agreement is a bilateral contract. A bilateral contract is the exchange of a promise for a promise. The seller promises to pay the commission if the licensee finds a buyer. The licensee promises to use due diligence to find a buyer. A is incorrect. Under the exclusive right to sell listing agreement, the licensee will earn a commission if a buyer is found during the term of the contract. It does not matter who finds the buyer. The exclusive right to sell is a bilateral contract. This type of listing agreement provides the maximum protection for the licensee. B is incorrect. This type of contract is by and between a licensee and a buyer. D is incorrect. The open listing agreement is a unilateral contract. A unilateral contract is the exchange of a promise for performance. The seller is promising to pay a commission to the one licensee who performs and finds a buyer. It is not exclusive, meaning there can be multiple licensees from multiple brokerage firms working to find a buyer. If the seller finds a buyer, none of the licensees will earn a commission. Finally, there does not need to be a specific termination date for an open listing. Question 32. Selma lists her property with XYZ Realty, ABC Realty, and MNO Realty. In each listing agreement, Selma has agreed to pay a commission to the listing firm only if that firm finds a ready, willing, and able buyer and a sale is consummated. This type of listing is _______________________ an exclusive agency listing, an open listing, an exclusive right to sell listing, an MLS listing. An open listing gives any real estate licensee who has a listing agreement with the seller the right to a commission if he finds the buyer for the home. An open listing gives the seller the right to establish many listing agreements with many brokerage firms and pay a commission only to the firm that finds the buyer. Sellers might be under the misguided impression that this type of listing gives them an advantage. However, in most cases, the listing agents in an open listing are not apt to market the property as aggressively if there is a possibility that another firm could find the buyer. Furthermore, most multiple listing services, MLS, specifically prohibit the publication of open listings in the MLS listings, so all marketing of the property must be done through other less effective means. Question 33. An owner of a parcel of vacant land and a prospective buyer enter into a written contract. For a non-refundable fee, the owner agrees to keep the prospective buyer's offer on a property open for a mutually acceptable period of time. If the prospective buyer decides to buy the vacant land, both parties have agreed to a purchase price. If the prospective buyer decides against purchasing the property, the owner will keep the non-refundable fee received from the prospective buyer at the time the contract was signed. Which term most accurately describes the contractual agreement between these two parties? Bilateral contract, option contract, purchase contract, unenforceable contract. The agreement described in this fact pattern is an option. An option is a unilateral contract. An option is a contractual agreement between an owner, the optioner, and a prospective buyer, the optionee. The owner agrees not to sell the property to anyone else during the period of time specified in the option. This is a unilateral contract, meaning it is the exchange of a promise for performance. Here, the owner is promising not to sell the property to anyone else until the prospective buyer decides either to buy, i.e., perform, or not buy. Whatever the prospective buyer decides, the owner of the property will keep the non-refundable option fee. During this option term, if the prospective buyer decides to exercise the option, the seller will sell the property to the prospective buyer at a price both parties have agreed to in the option agreement. Note, prospective tenants could also enter into an option with owners regarding prospective leasehold property. If the prospective tenant decides not to exercise the option, the owner would keep the non-refundable option fee. A is incorrect. A bilateral contract is the exchange of a promise for a promise. Here, the prospective buyer is not making a promise and has the freedom to walk away if deciding against the purchase of the property. C is incorrect. During an option term, the buyer is deciding whether or not to purchase the property. The owner and the prospective buyer are not yet parties to a purchase contract. If the prospective buyer decides to purchase the property, a bilateral purchase contract will be necessary. D is incorrect. An unenforceable contract prevents the victim of a breach of contract from going to court and suing. Here are some common examples of an unenforceable contract: a verbal contract when a writing is required, statute of frauds issue, a contract with an unlawful purpose, a contract past the statute of limitations, etc. There is nothing in the fact pattern to suggest that this option contract would be unenforceable in a court of law. Question 34. A valid contract must contain which of the following elements? Consideration, an offer and communicated acceptance, a legal object of the contract, all of the above. A valid contract must contain all of these elements. There must be an offer that sets forth clear terms and is more than a mere invitation to negotiation. The offer must be accepted without any conditions or qualifications, and the acceptance must be communicated to the person making the offer. There also must be consideration. For a bilateral contract, consideration is the exchange of promises. For example, in a purchase and sale contract, the seller is promising to convey title to the buyer, and the buyer is promising to pay the purchase price to the seller. Finally, the purpose of the contract must be lawful. Question 35. How much time must a prospective borrower be given to review the closing disclosure? 1 business day before closing, 2 business days before closing, 3 business days before closing, 1 week before closing. A prospective borrower must be given 3 business days to review the closing disclosure prior to the closing. This goal of this 3-day window is to give the consumer time to raise any questions with the lender prior to becoming obligated under the terms of the new loan. Test-taking tip: there is an exception to this 3-day rule for closing disclosures. If borrowers are undergoing a personal financial emergency, they can waive taking 3 business days to review the closing disclosure. An example of this type of emergency is when a borrower needs a new loan immediately in order to prevent an upcoming foreclosure sale. Note, lenders are required to provide consumers with both a loan estimate and a closing disclosure, and are not allowed to charge for either disclosure. The loan estimate must be delivered to the consumer within 3 business days after the loan application is submitted. Question 36. The law in all states provides that contracts for the sale of real estate or an interest in real estate are unenforceable unless they are in writing and signed by the parties. What law is this? Statute of limitations, statute of estoppel, statute of real estate, statute of frauds. Contracts for the sale or purchase of real estate are unenforceable in a court of law unless they are in writing and signed by the parties to be charged. The purpose of the statute of frauds is to prevent fraud by a person seeking to enforce a contract that was never made. The statute was not designed to prevent oral contracts. One exception to this rule is oral leases for a period not exceeding 1 year. Such leases are enforceable if the intent of the parties can be established in court. Question 37. A 50-year-old surgeon was the sole owner of a parcel of residential real estate. She wanted her eldest son to have this parcel after she died. The mother properly executed a legal deed, designating him as the grantee to the property. "I have put the deed in the top left-hand drawer of my desk," she told her son. "After I have died, you will find the deed there, and the property will be yours and yours alone." 20 years later, she passed away. The son found the executed deed in her desk drawer. This fact pattern shows lack of capacity, improper delivery, concurrent ownership, invalid deed. These facts reflect improper delivery of the deed. In order for title to transfer, there must be a valid deed as well as delivery and acceptance of the deed. A deed is delivered when there is intent to convey the property. Here, there was not even an intent to convey the property during the lifetime of the grantor. If the mother did not want to convey her property until after she passed, she should have used a will, a trust, or, perhaps, a deed creating a life estate in herself with a remainder interest in the son. A is incorrect. There is nothing in the fact pattern to suggest a lack of capacity. Issues relating to lack of capacity might have to do with an unemancipated minor attempting to sign a deed, a mentally incompetent grantor, or a grantor who executed a deed while drunk or drugged. C is incorrect. Concurrent ownership occurs when multiple people own the same parcel of real estate together. The fact pattern states that the surgeon was the sole owner of the property when she executed the deed, and wanted her son to be the sole owner of the property after she passed. D is incorrect. The test question states that the surgeon properly executed a legal deed. Question 38. The legal act of transferring ownership, or the intention to have a deed be operative and effective is manifested by underscore 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 of the deed. Delivery, acceptance, notary, recording. The intent to transfer is manifested by delivery of the deed. Deeds become valid upon delivery, acceptance and notification to the deliverer of the acceptance. In most states, delivery happens when the grantor, seller, signs the deed. Notification to the deliverer that the deed has been accepted occurs when the deed is recorded. The method of legal acceptance of a deed varies by state. Question 39. A basic owner's title insurance policy will cover all of the following except underscore 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 underscore. Forgery or fraud, improper delivery, lack of capacity, building permit or zoning violations. The basic owner's title insurance policy typically does not cover violations related to building permit violations or zoning violations. A, B, and C are incorrect answer choices. These answer choices show items typically covered under the basic owner's policy. Note, matters of record that were not discovered by the title insurance company during their search and are unknown to the owner would also be covered under this type of policy. However, if an owner knows about a problem prior to the issuance of an owner's title insurance policy, then the title insurance company would exclude it from coverage under the policy. Question 40. A mortgagee's policy of title insurance is valid until the owner dies. The owner sells the property. The mortgagee neglects to renew the title insurance policy. The loan is paid in full. Mortgagee means lender. A lender's policy of title insurance remains in force until the loan is paid in full. Test-taking tip: the coverage under a lender's policy of title insurance declines as the loan is being paid off. After the loan is paid in full, the coverage expires. A and B are incorrect. A lender's policy of title insurance will remain in effect as long as loan is outstanding. The owner dying or selling the property would not in and of itself terminate a lender's policy of title insurance. C is incorrect. A title insurance policy premium is paid only once, usually at the closing. Question 41. A buyer is applying for an ARM loan. Do the payments on this type of loan product change? No. They stay the same over the course of the loan. Yes. The interest rate changes annually, either raising or lowering the payment. Yes. The interest rate goes up every year. Yes. The interest rate goes down every year. ARM stands for Adjustable Rate Mortgage. In contrast to the fixed-rate mortgage, the ARM interest rate is tied to an economic index and can go up or down, depending on market trends. Typically, the ARM loan adjusts annually, but lender and borrower can negotiate how frequently an adjustment can occur. A is incorrect. The interest rate on an adjustable rate mortgage is periodically adjusted based on an economic index published by a neutral third party. The loan paperwork states which economic index the lender will follow. C and D are incorrect. The interest rate on an ARM loan is variable and can either rise or fall, depending on current market conditions. Question 42. The Real Estate Settlement Procedure Act, RESPA, applies to what types of real estate transactions? All cash sales, sales involving seller financing, federally related mortgage loans, all of the above. RESPA applies to federally related mortgage loans. Because nearly all loans on residential properties are federally related, RESPA regulations cover the vast majority of residential loans. Here are some of the loans that are considered federally related: VA guaranteed loans, FHA insured loans, loans intended to be sold onto the secondary mortgage market, lenders with FDIC, etc. A, B, and D are incorrect. These incorrect answer choices are examples of loans not subject to RESPA. Other exempt loans include commercial loans, business loans, land contracts, and loans for land tracts of 25 or more acres, etc. Question 43. You sell a home for a client where the down payment was $30,000 with a loan of $125,000 at 3.7% interest with a term of 30 years fixed. The mortgagor's monthly payment is $1,219. What is the loan-to-value ratio? 0.24, 0.8, 1.62, 4.16. $30,000 plus $125,000 equals $155,000 sale price. $125,000 divided by $155,000 equals 0.8 LTV. Question 44. What must a homeowner in foreclosure do to exercise his right of redemption? Pay the entire mortgage. Pay the entire mortgage, plus interest. Pay the entire mortgage, plus court costs and legal fees. Pay the entire mortgage, plus court costs, legal fees and interest. There are two phases in a foreclosure: reinstatement, the first phase, and redemption, the second phase. During the reinstatement phase, the homeowner must only pay any missed mortgage payments, plus court costs, legal fees and interest. This will cure the default and allow the homeowner to continue paying off the mortgage. During the redemption phase, the homeowner must pay the entire outstanding mortgage loan amount, plus court costs, legal fees, and interest. Redeeming a property means saving it from foreclosure. A, B, and C are incorrect because they are incomplete. In order to exercise the right of redemption and save the property from foreclosure, the property owner must pay the entire outstanding mortgage, court costs, legal fees, and any interest owed. Question 45. A homeowner has a mortgage with a fixed interest rate. Under what circumstances would her payments change? None. The payment will not change over the life of the loan. The property taxes go up or down. The cost of homeowner's insurance goes up or down. Either B or C. Here, the test question states that the homeowner has a mortgage with a fixed interest rate. Especially when interest rates are low, a mortgage with a fixed interest rate is appealing to borrowers because the interest rate and the amount of the monthly loan payment will not change over the entire term of the loan. The question, however, is testing your knowledge of mortgage impound accounts, aka mortgage escrow accounts. These accounts are set up by lenders to hold the borrower's money for expenses that are charged to the property and unrelated to the loan, example, property taxes, homeowner's insurance, hazard insurance, etc. Lenders collect funds along with the borrower's mortgage payment to ensure that property taxes and insurance premiums are paid. Because the amount of these property-related expenses can change over time, the monthly payment due the lender might vary, even when the loan itself has a fixed interest rate. A is incorrect. This statement accurately describes a mortgage with a fixed interest rate, but does not account for a lender collecting whatever is needed to cover changes in property taxes and insurance premiums. Question 46. Which of the following types of mortgages will probably have the lowest initial interest rate? Conventional 30-year fixed rate. 30-year fixed rate FHA loan. Conventional 15-year fixed rate. Conventional 30-year ARM. ARM stands for adjustable rate mortgage, aka variable rate mortgage. While the interest on a fixed-rate mortgage does not change over the term of the loan, the ARM interest rate is tied to an economic index and can go up or down, depending on market trends. Many ARM loans start at a lower interest rate than the fixed-rate mortgage. Then, following this introductory period, the interest rate is tied to changes in an economic index and can either rise or fall. A, B, and C are incorrect because they are all fixed-rate mortgage loans. Question 47. The loan-to-value, LTV, ratio is the maximum amount a lender will lend to finance a loan collateralized by real estate. The loan is based on a percentage of either the purchase price or the appraisal, whichever is less. The 20% down payment lenders traditionally required with conventional financing put homeownership beyond the reach of many Americans. FHA fully insured financing substantially lowers the down payment lenders require for the purchase of a home because FHA mortgage insurance minimizes lender risk in the event of borrower default. All of the following statements are incorrect, except FHA is a direct lender. FHA is a joint lender with HUD-approved institutional lenders. FHA-insured loans have a lower LTV ratio than conventional loans. FHA insurance premiums may be paid at the close of escrow or financed into the loan. FHA mortgage insurance premiums, MIPs, can be paid at closing or included into the loan amount and paid monthly. FHA mortgage default insurance protects lenders in the event of borrower default. A is incorrect. FHA is not a direct lender. B is incorrect. FHA is not a joint lender, but provides borrower-paid insurance to protect lenders in the event the borrower defaults on the loan. However, for FHA fully insured financing, the loan must be through an institutional lender approved by the Federal Housing and Urban Development, HUD. C is incorrect. FHA fully insured loans have a higher LTV ratio than conventional loans. In fact, borrowers with an FHA loan may only need to make a 3.5% down payment. Test-taking tip: examiners occasionally will try to confuse students by writing complicated test questions like, all of the following are incorrect, except. When faced with this type of test question, simplify the confusing language into a true/false question. For example, a simpler way of phrasing this question is, which answer choice is true? Question 48. What is the name of the lender in a three-party security instrument that hypothecates real estate? Mortgager, mortgagee, beneficiary, truster. A three-party security instrument that hypothecates real estate is called a deed of trust. The deed of trust, aka a trust deed, is one of the documents the borrower signs when getting a loan using real estate as collateral. A deed of trust creates a voluntary lien on the real estate of the borrower. The three parties to this legal instrument are the lender, beneficiary, the borrower, truster, and the trustee, the third party to whom the borrower conveys bare legal title for the lifetime of the loan. Test-taking tip: make sure you memorize the information in your study materials related to trust deeds. Even if deeds of trust are uncommon in your state, you are very likely to be tested on this subject. Note: during the lifetime of the loan, the trustee under a trust deed will hold bare legal title to the property. When the loan is paid in full, the trustee must reconvey bare legal title back to the borrower, and does so using a document called a deed of reconveyance. However, if the borrower defaults on the loan, example, stops making loan payments, permits the real estate to fall into disrepair, etc., the trustee typically administers the foreclosure and conveys the property to the high bidder at the foreclosure sale using a trustee's deed upon sale. A is incorrect. A mortgager is the name of the borrower in a two-party security instrument called a mortgage. B is incorrect. A mortgagee is the name of a lender in a mortgage. Test-taking tip: like the trust deed, the mortgage also creates a voluntary lien on the property. However, in contrast to the trust deed, it is only a lien, no portion of title is conveyed by a mortgage. D is incorrect. The truster is the name of the borrower in a deed of trust. Test-taking tip: make sure you spend some study time going through the glossary in your licensing materials. Examiners frequently test knowledge of technical words and terms like hypothecate to pledge real estate without giving up possession. Question 49. A lender is required under the Truth in Lending Act, Regulation Z, to furnish an applicant for a real estate loan with a copy of A_______________________________________________________________________________________________________________________ This document must be given to the borrower before the borrower can be obligated to repay the loan. Amortization schedule, disclosure statement, deed, financial statement. Regulation Z requires that lenders furnish an applicant for a real estate loan with a statement that discloses the finance charges associated with a loan. The Truth in Lending disclosure statement shows the annual percentage, which is the borrower's cost of credit as an annual rate, and the total amount the borrower will repay to the lender in comparison with the amount financed. Question 50. A real estate brokerage firm specializes in property management. Which one of the following property management activities is illegal? Achieving a more diverse tenant population through racial screening of prospective tenants. Failing to give a lead-based paint warning for an apartment building built in 1987. Rejecting families with minor children from senior housing. Rejecting hard-working tenants based on their financial credit scores and history. Discrimination on the basis of race in the purchase or leasing of real estate is always illegal even when the goal is racial diversity. Test-taking tip: race is the only protected class in the Civil Rights Act of 1866. Race is one of multiple protected classes in the Civil Rights Act of 1968, as amended. B is incorrect. Lead-based paint warnings are required for both sales and rentals if construction began prior to January 1, 1978. Unless there is actual knowledge of lead-based paint on the premises, a warning is unnecessary for an improvement constructed in 1987. Test-taking tip: make sure you know what is considered target housing for lead-based paint warnings, i.e., pretty much any residential property constructed before 1978. C is incorrect. If a complex complies with federal rules related to senior citizen housing, owners and property managers are legally permitted to exclude families with minor children. Note: per federal rules, a senior is someone who is 55 years old or older. D is incorrect. One of the property manager's most important duties is to find well-qualified tenants who are financially able to rent the leasehold property. Question 51. Underscore 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 is not part of the property manager's responsibilities. Fairness and honesty. Keeping up with rental rates in the area. Telling the owner the market value of the building. Keeping up with vacancies. A property manager is obligated to stay informed about market rents in the area and track vacancies in the building being managed. However, the property manager has no obligation to the principal to stay informed on market value of the building. Fairness and honesty are always a part of a property manager's responsibilities as a party of the duty of agency. Question 52. In the middle of one of the worst snowstorms in the last 20 years, the heat went out in lessee's residential apartment unit. Lessee immediately called and spoke to lessor to report the problem. Lessor promised to have the heater fixed, but was vague about when the repair would occur. Lessee followed up with multiple phone calls, texts, and emails. After several days without heat, lessee abandoned the residential rental unit and subsequently refused to pay rent for the remaining term of the lease. Lessor sued lessee for the unpaid rent. Who will most likely win the lawsuit? Lessor. A lease is a contract. Lessee, by failing to pay rent, was in breach. Lessor. The lessee must maintain necessities such as heat on a leasehold property. Lessee. This is a breach of the covenant of quiet enjoyment. Lessee. This is a breach of the warranty of habitability. The landlord breached the implied warranty of habitability. For many jurisdictions across the United States, this promise of a habitable living environment is implied by law in residential leases. It need not be discussed verbally or included in writing in the lease. The basic living and safety standards in this implied warranty include necessities such as heat, plumbing, electrical systems, and water. By not responding in a timely manner to the tenant's repeated calls for help, the landlord was in breach of the implied warranty of habitability. Therefore, the tenant's abandonment of the leasehold property and subsequent refusal to pay rent would most likely be found by a court to be justified, relieving the tenant from any further obligations under the lease. Note: a failure on the part of the landlord to make a residential rental property habitable is referred to as constructive eviction. This is not physical or legal eviction, but rather a failure on the part of the landlord that significantly affects the tenant's possession, enjoyment, or use of the leasehold property. A is incorrect. This answer choice states the general rule, but a breach of the implied warranty of habitability may relieve the residential tenant of any further contractual obligations, including payment of rent. B is incorrect. In most jurisdictions, the landlord is responsible for keeping necessities such as heat, plumbing, water, and electrical systems in good repair. C is incorrect. Another promise many jurisdictions imply into residential leases is the covenant of quiet enjoyment, an implied promise that no one claiming superior title will disturb the tenant's possession of the leasehold property. However, There is one important exception to the covenant of quiet enjoyment. If there is an emergency situation on the leasehold property, the landlord has the right to enter the property unannounced to repair the emergency. Test-taking tip: note the use of the terms lessor/lessee rather than landlord/tenant throughout this test question. Make sure you memorize all the or/ee terms in your study materials. Example: optioner/optionee, mortgager/mortgagee, truster/trustee, grantor/grantee, vendor/vendee, lessor/lessee, etc. The examines will frequently use these somewhat technical terms in test questions rather than the words used in everyday speech. Question 53. Robin rents a unit from owner Joaquin. Therefore Joaquin is the lessee and Robin is the lessor. Joaquin is the lessor and Robin is the lessee. Robin is a lessor and Joaquin is a landlord. Joaquin is a lessee and Robin is a tenant. The landlord or property owner is the lessor, or the person giving the lease rights. The tenant is the lessee, or the person receiving the lease rights. Question 54. You are trying to price a property. 5 years ago it was sold for $125,000, but property values in this particular neighborhood have decreased by an average of 5% since then. What is the rough value of this property? $117,500, $118,750, $118,000, $119,000. $125,000 x 0.05 equals $6,250. $125,000 to $6,250 equals $118,750. Question 55. Who can legally appraise a residential property when the purchase is being financed with an FHA-insured loan? The lender financing the purchase money mortgage. A licensed appraiser. A broker hired to provide a broker opinion of value. A home inspector. Only a licensed appraiser can perform an appraisal. An appraisal is required for all federally related loans like, for example, an FHA-insured loan, a VA-guaranteed loan, a conventional loan, and loans from lenders with FDIC. A is incorrect. The lender, however, needs the appraisal to ensure that the loan-to-value ratio is appropriate. C is incorrect. The broker opinion of value, aka broker price opinion, is the broker's estimation of a property's market value based on recent sales of nearby comparable properties. While this approach is similar to the market data approach used by appraisers, the broker is not authorized to complete an appraisal. D is incorrect. A home inspector does not appraise a property, but reports on the condition of its major systems and components, example electrical, plumbing, foundation, walls, insulation, heating, air conditioning, etc. Question 56. An appraiser is hired to appraise a single-family residence as part of a purchase transaction. The subject property has 4 bedrooms and 4 bathrooms. The appraiser needs comparables to complete the appraisal, and finds 3 recently sold properties in the same subdivision. The first comparable has 4 bedrooms and 4 bathrooms. The second comparable has 4 bedrooms and 3 bathrooms. The third comparable has 3 bedrooms and 4 bathrooms. What is a correct statement regarding the market data approach? The market data approach requires that the comparables have the same number of bedrooms and bathrooms as the subject property. Adjustments must be made to the subject property to make it match the comparables. The value of a bathroom must be added to the sales price of the second comparable. The value of a bedroom must be subtracted from the sales price of the third comparable. In comparison to the single-family residence being appraised, frequently referred to as the subject property, the second comparable is missing a bathroom. The value of a bathroom must be added to the sales price of the second comparable so that it more accurately reflects the market value of the subject property. A is incorrect. Although appraisers look for comparables that are as close as possible to the subject property, the comparables do not have to have the exact same number of bedrooms and bathrooms. The appraiser will adjust the sales prices of the comparables to account for differences between a recently sold comparable and the subject property. It is the job of the appraiser to know, for example, what a bedroom or a bathroom is worth in a particular neighborhood. B is incorrect. Adjustments are made to the recent sales prices of the comparables, not to the subject property. D is incorrect. The third comparable has only 3 bedrooms, while the subject property has 4 bedrooms. The value of a bedroom must be added to not subtracted from the sales price of the third comparable. Note, the market data approach is also called the sales comparison approach. Question 57. The principle of appraisal that dictates that home values tend to increase when demand increases is the principle of underscore 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 progression, substitution, regression, supply and demand. The principle of supply and demand is the oldest principle of economics, and it is also the most predictable principle. When demand for homes increase because of national economic influences, such as lower interest rates, values tend to increase. Also, when demand increases because of local changes, such as a new business coming to the area, or an influx of new residents, values will increase. Question 58. The monthly net income on an investment of $115,000 if the rate of return is 12.5% is underscore 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 $1,150, $7,666.67, $1,197.92, $14,375. $115,000 x 0.125 equals $14,375. $14,375 divided by 12 equals $1,197.92. Question 59. James Jordan purchases single-family residences to use as residential rental properties. He currently owns 4 properties in the same approximate geographic area, and is considering the purchase of another single-family residence situated nearby. In order to avoid the cost of an appraisal, Jordan uses the gross rent multiplier, GRM, to help him make an appropriate offer. Jordan knows that the monthly GRM for his 4 current properties is 200. In order to maintain a GRM of 200 for a property with a current monthly rent of $2,500, how much should Jordan's offer be? $400,000, $500,000, $600,000, $700,000. In order to maintain a gross rent multiplier of 200, Jordan's offer for this additional property should be $500,000. The gross rent multiplier, aka the gross income multiplier, is a simpler, less accurate alternative to capitalization. Takes into account the income generated by a parcel of real estate, but not the expenses charged to the property. This alternative to capitalization is most widely used with single-family residences. There are the 3 mathematical relationships related to the gross rent multiplier you should know for your exam. Gross rent multiplier x rent equals value. Example, 200 GRM x $2,500 rent equals $500,000 value. Value divided by rent equals gross rent multiplier. Example, $500,000 value divided by $2,500 rent equals 200 GRM. Value divided by gross rent multiplier equals rent. Example, $500,000 value divided by 200 GRM equals $2,500 rent. Here, the test question states that the current monthly rent paid for the property is $2,500. Jordan's other properties have a gross rent multiplier of 200. In order to maintain this gross rent multiplier, Jordan would multiply the gross rent multiplier, 200, by the rent, $2,500, and make an offer of $500,000 on the property. A is incorrect. This offer would result in a gross rent multiplier of 160. $400,000 divided by $2,500 equals 160 GRM. If Jordan's 4 other properties in the neighborhood have a gross rent multiplier of 200, it is unlikely that the seller will accept this low an offer. C and D are incorrect. These offers would result in a gross rent multiplier that would be too high for this particular neighborhood and Jordan's 4 other properties. Example, $600,000 divided by $2,500 equals 240 and $700,000 divided by $2,500 equals 280. Question 60. Investing can best be defined as underscore 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 underscore. Giving up present spending in exchange for future benefits. Buying real estate for all cash. Saving for future consumption. Revenue exceeding costs. Investing in real estate is the act of giving up money that could be spent elsewhere in exchange for the potential for profit in the future. The likelihood of a profit is called the risk. As a rule, the greater the risk, the lower the investment. Investment in vacant land is a low-risk investment because vacant land does not tend to depreciate as much or as fast as improved land, and the cost to purchase vacant land is usually lower than the cost to purchase improved land. Question 61. The presence of lead paint in a home must only be disclosed if the home is being purchased using an FHA loan. True. False. Federal lead-based paint disclosures have nothing to do with the type of loan used to purchase a home. This federal law requires lead-based paint disclosures when the residential property offered either for sale or lease was constructed prior to 1978. Residential housing constructed prior to 1978 is called target housing. For target housing, a prospective tenant must be given the EPA-approved pamphlet on the dangers of lead. The EPA-approved pamphlet must also be given to prospective purchasers of target housing. But, additionally, prospective purchasers must be given a 10-day window to have the home tested for lead-based paint. Prospective buyers can waive testing. In fact, no party is legally obligated to test or pay for removal of lead-based paint. Finally, even if construction began after January 1, 1978, actual knowledge of lead-based paint on the premises must be disclosed to both prospective tenants and prospective buyers. Note: federal lead-based paint disclosures are strict because lead poisoning can cause significant neurological damage, particularly to small children. Test-taking tip: lead-based paint disclosures are the responsibility of the seller or the landlord. However, if there is a real estate licensee involved in a transaction, the licensee has a duty to make sure the client is both aware of and has complied with the lead-based paint rules. In fact, licensees, buyers, and sellers all must sign the lead-based paint hazard addendum, which is attached to the purchase contract or lease. Question 62. Construction on a single-family residence in a new subdivision started on June 1, 1977. Construction was completed on January 1, 1978. The current owner, John Ng, acquired the property via first deed out from the developer. The property has not been remodeled or rebuilt since it was originally constructed. Ng is now selling the property and is represented by a licensee. All of the following choices related to compliance with federal lead-based paint disclosure rules are incorrect, except because construction was completed on January 1, 1978. There are no federal disclosure requirements related to lead-based paint. The licensee is responsible for compliance with federal lead-based paint disclosures. The seller must inform prospective buyers of any lead-based paint he knows is on the property. The seller is responsible for having the property professionally inspected for lead-based paint. With regard to federal lead-based paint disclosure rules, target housing includes residential dwellings built before January 1, 1978. This is the difference that one day can make. If construction started on December 31, 1977, then the residential dwelling is target housing, and lead-based paint warnings must be given to prospective buyers and tenants. If construction started on January 1, 1978, then the dwelling is not target housing, and the lead-based paint disclosure requirements do not apply. However, even if construction of the house commenced on or after January 1, 1978, a seller or landlord with actual knowledge of lead-based paint on the property is under a duty to disclose this to prospective purchasers and tenants. A is incorrect. Answer choice A misstates the rule. If construction started on January 1, 1978, then the house would not be considered target housing, and, absent actual knowledge of lead-based paint on the property, there would be no federal lead-based paint disclosure requirements. B is incorrect. The seller or landlord is responsible for compliance with lead-based paint disclosures. Compliance is not waived if there is no licensee involved in the transaction. A licensee, however, if involved with the transaction, is responsible for advising the client as to proper disclosure and compliance. D is incorrect. Sellers and licensees are under no obligation to order an inspection to have the house tested for lead-based paint, or to pay for repairs if lead-based paint is discovered. Prospective buyers must be given a 10-day window to have the property inspected for lead-based paint, but even prospective buyers are free to waive testing. Question 63. The process that involves covering a landfill with 2 to 4 feet of clay-like soil and planting grass on the soil is the process of soiling, capping, chipping, remediation. Landfills and the toxins and chemical byproducts of the refuse are a major cause of groundwater contamination because rainwater and snowmelt can filter through the refuse and dissolve a wide range of water-soluble pollutants, which then seeps into the ground. The process of capping mitigates this process because the clay-like soil forms a barrier so that most of the water stays above the level of the refuse and less water filters through the refuse. Question 64. Seller is selling a condominium. Seller and buyer agree upon a sale price of $450,000. Seller has prepaid the property taxes for the entire tax year. Buyer will be moving into the property 4 months prior to the end of the tax year. Seller must pay off an outstanding mortgage lien of $350,000 and a mechanics lien of $2,500. Seller must also pay the brokerage fee to the licensee who brought the ready, willing, and able buyer to the transaction. In the closing statement prepared by the settlement officer, which of the following will be a credit to the seller? Payoff of the $350,000 mortgage lien. Payoff of the $2,500 mechanics lien. Brokerage fee. Prepaid property taxes. The seller will be reimbursed for the prepaid property taxes for those 4 months of the remaining tax year when the buyer will own the property. The other answer choices are all considered debits to the seller. Test-taking tip: a good way to remember this is that, for the settlement officer, a credit increases what a party can take from the closing, while a debit decreases what a party takes from the closing. In this test question, the prepaid property taxes will be a credit to the seller and a debit to the buyer. However, debits and credits on the closing statement are not always balanced equally between the two parties. Here, for example, the seller must pay off the outstanding mortgage lien, the mechanics lien, and the brokerage fee, but these are not considered credits to the buyer. Question 65. Which of the following is the standard real estate settlement form for federally related mortgage loans? Good faith estimate settlement statement. Truth in lending disclosure statement. HUD-1 settlement statement. Regulation Z settlement statement. The HUD-1 settlement statement is a standard form in use to itemize services and fees charged to the borrower by the lender or broker when applying for a loan. A final HUD-1 statement must be given to buyers 1 day prior to the signing of the documents. The HUD-1 settlement statement also contains a good faith estimate, GFE, which specifies the estimated loan costs. Question 66. A developer purchases unimproved property to build a new subdivision. The land is $3,542.45 per acre. Here is the legal description of the property purchased, the northwest quarter of the southeast quarter, of Section 26. The acreage in Section 26 is typical for the government survey system. How much money did the developer pay in total for the property? $106,273.50. $141,698. $212,547. $566,792. In the government survey system, aka rectangular survey system, an entire section of land is 1 square mile. 1 square mile contains 640 acres. 1/4 of a section has 160 acres. 640 divided by 4 equals 160. 1/4 of a quarter section has 40 acres. 160 divided by 4 equals 40. Here, the legal description states that the purchased property is 1/4 of a section, thus, 40 acres. If the land is $3,542.45 per acre and the land purchased is 40 acres, then the purchase price is $141,698. $3,542.45 x 40 equals $141,698. A is incorrect. This would be the correct purchase price for a 30-acre parcel. C is incorrect. This would be the correct purchase price for a 60-acre parcel. D is incorrect. This would be the correct price for a 160-acre parcel.